I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are courtroom hopping into the courtroom of Judge Jeffrey Middleton out of the state of Michigan. And we are in Judge Middleton's courtroom for a follow-up on a couple that we covered, a sovereign citizen couple by the name of Mr. and Mrs. Yoder. And if you remember them, they were an Amish couple, and maybe you don't. And if you don't, that's fine, because we will have the links in the description to those previous videos that we shared, because we actually had to break up that last proceeding into 3 different videos because they were so long. And what I'm actually going to do is at least share the previous video with this one, because this is something new where they just appeared in Judge Middleton's courtroom with some new motions. So I'm going to add that, and I'm also going to leave my commentary on the end of that 3rd video that I'm going to add to this, so that way you can get an understanding of some of the things that went on and some of the things that happened. But I really encourage you, if you don't know anything about this case, go back to the beginning and watch from the beginning, because that way it will make a lot more sense to you. So we're going to get ready to get into this motion hearing. Like I said, first it will be that previous video. If you've seen that, chapters will be added. You can skip right over that. If you haven't, if you're not willing to go all the way back, at least watch that to give you a little bit of understanding of what's going on, and then you'll see why they filed the motions that they did recently. Now, let's go ahead, guys, and jump into Judge Middleton's courtroom.
All right, we're back. Let's go back on the record. We return to our hearing in Colon Township versus Alfred and Joanne Yoder. File number is 25040CZ. Testimony portion of this hearing has been completed. Court's heard testimony under oath. We've received 6 exhibits, and I'm going to give each of the parties an opportunity now to argue what they think should happen. Mr. Thornton.
Yes, Your Honor, and my comments will be relatively brief. The Yoders made a decision to not participate, essentially, in this case when they should have participated in it and had the opportunity to participate in it and be heard. They then, after the court's default judgment and permanent injunction entered, and it's very clear that they were aware of that default judgment and permanent injunction. It was served upon them. They knew what it said. They then, because they disagreed with the decision, they intentionally kept violating the order. It is very obvious from March 13th through now, and from the exhibit entered on the number of births out there, that the births could have stopped much sooner than they did. And I'm not sure from the testimony given by the Yoders that they intend to permanently stop them at this point, but I guess we'll see on that. My point is that the Yoders' contempt, and I think they are in contempt of Judge Stutzman's and this court's order, was intentional. And only from the township's persistence in getting to this hearing are we here today in almost the end of September. So the township is going to request a fine under MCL 600.1701, actually 600.1715, of $3,500 per defendant to get the point across that The circuit court's orders are that and need to be followed or legally contested.
And pay the original $243. Now I have $2,000 of bond money, which I can allocate toward fines and costs.
Yes, we still want the $248 or
Yes.
whatever it was. And my understanding, the township gets none of that $7,000. So I would request, and the statute does provide for restitution to the township. I'm not prepared today to submit a detailed accounting of how much extra cost the township was imposed. I understand we're not going to get, the township's not going to get its attorney's fees for the entire case, but it seems unfair to the township, to the missed hearings, the appearances I appeared for, the motion and order to show cause proceedings, the impromptu unscheduled hearing when the Yoders unexpectedly showed up at the courthouse, and then today's proceeding. I would like to request to the time to submit a request for the court's consideration to award restitution directly to the township for some of those extra fees and costs that they incurred.
That's generally called a bill of costs. As you know, I often, in fact, usually give any fine money to the township as restitution rather than keep it to the county. Zoning enforcement's expensive. If a policeman charges someone with a crime, with drunk driving, the county pays for the prosecutor, the county pays for the judge. It doesn't work that way for the townships. If the township proceeds to enforce an ordinance, the township pays for it. And if there's a lawsuit, there was a lawsuit in my township that cost the township about $25,000 in attorney fees, and they lost. So my practice is often to just give any court fine money that would go to the court to the township to offset the cost of the case. All right, so you're asking for $3,500 per defendant. The maximum would be $7,500. And that I allocate that as restitution, but we need a bill of costs and a further restitution hearing. All right, thank you.
And the 240.
And the 248. And as I indicated, I've got $2,000 in escrow from their cash bonds that they posted. All right, Mr. and Mrs. Yoder, their contention is that you violated Judge Stutzman's order by continuing to have births at your center. Now let's repeat. You changed the name of the enterprise from Mama's Birthing Center to Mama's Ministry. And it is a ministry. I guess I won't deny that. It's part of an overall worldview of things. But the ministry or Mama's Birthing Center wasn't charged. You were. It's in Alfred Yoder and Joanne Yoder's name. So as Mr. Thornton argued, that name change is irrelevant, but it isn't really that easy. People do that. They're sued on a debt. They owe somebody money, and they change the name of the company and say, well, I don't owe the money anymore. That company doesn't exist. Maybe that might work sometimes if there's a corporation or something. The other thing people will do is they'll transfer the property to somebody else for $1. Somebody's got a horrific toxic waste site, and the township pursues enforcement and they transfer it to their granddaughter for $1 or something, and argue we don't own that property anymore. Sometimes we have to parse that out. At any rate, this action is against the two of you, Judge Stutzman ordered back in March that you not have any more births at that center in terms of a permanent injunction. Doesn't matter what the name of it is, you can't do this at that place. And you had birth through April, May, June, July, September, and I'll take it at your word that there weren't any births after August 29th and none in September. Obviously, your place is, well, if we've had 87 births in 5 months, you're busier than some of the hospitals. I suspect there weren't 87 births at Sturgis or Three Rivers Hospital during that period of time. At any rate, they did present sufficient evidence that you've continued to have births there in violation of that order of March 13th. So I find that you are in contempt. They're asking for $3,500 to make the point. I think the point is going to be made with the cost to the township of doing this. So we will set a hearing regarding the sanction after you submit a bill of costs. My inclination is to reimburse the township for their costs. That may be enough of a sting. And as I said, I do have $2,000 that I can apply to the fine and the contempt. I do fine beyond the required standard. The township has established that you're in contempt for continuing to hold births through the summer at this facility. Now, let's talk about what happens next. He ordered that you can't do this there permanently. You don't agree with that and have not agreed with it, and you have a right to disagree with it. What you don't have the right to do is to continue to do it. If you continue to do it, they're going to file a petition for criminal contempt, in which case I can put you in jail for violation of the order. I could order under the equitable authority under the zoning law that the facility be torn down. I don't want to do that, and I don't want to put you in jail. I want you to stop. What you need to do, you obviously have a constituency. People like your service. I heard a number of people get up at the county commission meeting and say that we need this, we want this, and why is the government messing around with this? So you got people that want your service. You need to do it somewhere where you're allowed to do it. There are places that you could cite this that would not be in a zoning violation. The township says you can't do it here. That wasn't up to me. They filed the action. There was a hearing. Judge Stutzman made a ruling. Again, you had an opportunity to participate in your defense, but you didn't. So now we're all stuck with the order. You can't do this here. This isn't an order, but my recommendation is find some place where you can do it. Your followers will find you. We're gonna set a second hearing regarding the amount of the fine. And Mr. Thornton will provide a bill of costs. You'll have an opportunity to object to that. And then I'll make a ruling on how much the fine is. We can set that for Wednesday, October 15th at 1:30. Does that work for you?
It does, you know. You said 1:30.
Yes. Mr. Thorne, I'd like you to do an order stating that the court found that the plaintiff had met their burden of proof and the defendants were found in contempt. And the court intends to order a civil fine or restitution. And they will set a hearing on the amount of that fine or Wednesday, October 15th at 1:30. All right, we now have to deal with the other case. Yes, Ms. Yoder?
For the Judge Stutzman hearing, I still feel that was very much, I mean, considering we had notified them, we had given them information about this is a private ministry, and being that would be totally out of their jurisdiction on doing anything like this against a private ministry before they made a court hearing. They had all of this, and then Judge Stutzman lied about it. He said that we attempted to file our paperwork and we did not. We did, it's all proven fact, it's stamped, it's dated. It was done February 6th.
Well, you can appeal these. His ruling has been made and you did not move to set the ruling aside or appeal it. So it stands. If you had some defenses that could have been raised, they weren't. Now, a higher court, higher than me, may have a different view of it. So it's difficult to appeal a case to the Court of Appeals. I've done it, and you'd be very, very difficult for you to do this without legal counsel. And they're probably going to uphold his ruling. So if you want to continue your ministry, my suggestion is you find a place to do it where it conforms with the zoning regulations. Then you can continue with your ministry. Your clientele can still utilize your services, and you'll be in compliance with the law. All right, we have the preliminary injunction. We're going to shift the record here to the next case, which is file 25533CZ. That was the default judgment that entered. Request for default was filed by the clerk. What's the date of this? It's filed August 23rd of 2025. And I did a preliminary injunction order in that case, which I'm pleased that the Yoders have attempted to comply with that since my order of August 29th. The order that Judge Stutzman entered had a reasonable time in it. That time is passed. So the date is September 1st. That date is passed, but there should be no further operation of Mama's House at this location after September 1st, 2025. So we're going to take out the reasonable time requirement. The people after that date have found other remedies. All right, let's shift to the new case, Mr. Thornton. That request for default was submitted. I haven't seen any response. What's your position regarding that?
Your Honor, I would like to call one witness, the township building official, to put on some brief testimony that would add a little bit to the admissions by the Yoders to the complaint, to each allegation in the complaint. And then I would request at that point, once that testimony is received, the entry of the proposed default judgment I submitted in this case.
Mr. Yoder, would you come forward again?
Actually, I don't.
I mean, Mr. Klein, I'm sorry.
Actually, it's Lance Bonifield.
Oh, all right. Mr. Bonifield, would you come forward? Good morning. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
And would you state your name?
Lance Bonifield,
Could you spell that for us?
LANCEBONIFIELD.
Mr. Thornton?
And you're employed by whom?
Safe Built.
And again, Safe Built has a contract with Colon Township, correct?
Yes.
To provide building code official services. Is that correct?
Inspections.
Inspections. Okay. And are you the present person that does that in Colon Township for
Yes.
Safe Built and Colon Township?
Yeah, I do plan reviews and in building inspection.
And are you familiar with the Alfred and Joanne Yoder's property commonly known as 30246 Marsh Road, Colon, Michigan?
Yes.
And this has a fairly recently built, quite large structure on it, correct?
Yes.
Approximately a 6,400 square foot structure.
Yeah.
And as part of preparation for today's hearing, I asked you to review Safe Built's entire file on this property. Is that correct?
Yes.
Did you do that?
Yes.
It's already established by the pleadings, the verified complaint and the failure to answer those allegations have been admitted that 2 stop work orders entered on this property. Is that your understanding?
Yes.
The first one entered on February 2nd of 2024. Is that correct?
Yes.
And the second one entered on April 8th of 2025. Is that
Yes.
correct? No, you didn't post those stop work orders. Somebody else with Safe Built did. Is that accurate?
Yes.
But you know that information from reviewing the file.
Yes.
Have, in your review of the file, can you tell us whether either of those stop work orders were ever rescinded or terminated by Safe Built or Colon Township?
No, they haven't been.
So they are still in place.
Yes.
Having reviewed Safe Built's file on this matter, can you tell the court whether building inspections have been conducted on the structure located at 30246 Marsh Road?
The only inspection performed there was footing inspection.
Would there have been, should there have been other inspections performed?
Yes.
What is the kind of the status of that building?
Well, several inspections haven't been done, and I saw that when I went there. We should have had framing, insulation, whatever trade happening there, roofing and final. Those haven't been done.
Haven't been requested by the
No.
Yoders. So therefore haven't been, the structure has not been inspected.
Yes.
What state? is
All right,
this?
let me start. That includes electrical, mechanical, plumbing inspections.
Correct.
If we went out there today, what would we see? What status is that building in? How far along is it?
Final. It would be complete. Or the last time I was there was to post some documents on the door, and there was some siding that wasn't done and some site work that wasn't done.
But you viewed the inside of the structure through windows, is my
Yeah.
understanding?
And it's drywalled and the flooring is in complete.
And there is no and has been no building permit on this building for quite some time, correct?
Correct.
The former contractor that pulled the building permit terminated the permit, correct?
Yes.
In your opinion, or do you have an opinion as to whether this structure as built and as viewed by you the last time you were out there, is it built as a home or is it built as something else?
It looks like a healthcare facility to me. I opened up the drawings and looked at the floor plan. It looks like patient care rooms,
Is there a kitchen?
no kitchen. It's not in the drawings.
That's all I have, Your Honor. Again, that's in addition to all the verified allegations in the complaint that are considered admitted at this point.
Is there plumbing and bathrooms in the facility?
I'm not sure. I've never stepped into it.
Are they in the drawings?
I don't recall. All I looked at was the floor plan.
All right, thank you. Mr. and Mrs. Yoder, do you have any questions you wish to ask?
Yeah, I've got a little bit of a question on the affidavit for a search warrant. The affiant, or whatever they want to call it, is signed by Lance Bonifield. And from the FOIAs that were requested, he's got no valid oath of office. And if you go back to the Attorney General, he's got no right. It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue or serve occurrence tickets upon persons who violate the building code or the zoning ordinance of a city. It is my further opinion that the city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or charter provision.
What's the name of that opinion?
That's an affidavit for a search warrant.
No, the Attorney General opinion you just quoted from.
Frank J. Kelly,
Yeah, but what's the name of the parties?
Delta County, v. City of Gladstone, 305 Michigan, 50.8 NW 2D 908, 1943.
All right, county of, what county
And
is that?
on that same,
What county is that?
PA.
Delta County, v.
Alright.
City of Gladstone.
Also known as Happy Rock.
On the same affidavit for search warrant, it's a prosecuting official, Lance Thornton. I thought he's an attorney.
He
I
is,
think he's running two different deals on the same. And then if you go back to the search warrant,
And he doesn't have legal oath of office either.
we've got the officer as Lance Bonifield. If he's got no oath of office, he's an officer. So I'd say that whole thing's null and void.
all right.
For the, I've got motions here. I'd like to have, for you and Lance to have one of these.
Yes, would you hand them to the bailiff? Yes,
If I could respond to what he said.
well, you can ask him questions. We're not to the argument part yet, but if you have a question for him, you can ask it. Otherwise, I'll give you a chance to speak when we get there.
I'll just wait.
All right, this is, I'll get it date stamped by the clerk. I'll just put filed, bench filed. 9/24/25. I guess it's entitled motion to
Dismiss
Dismiss.
for lack of jurisdiction in violation of constitutional rights.
okay.
Introduction, defendant.
No, you
respect-
don't need to read it all. I've got it here. again, there's a timing issue. They filed this lawsuit. You had 21 days to respond. It did not respond.
We filed special occurrence papers.
That's not an answer to the complaint. And then the time to answer has passed. So, all right, yes.
So, as far as the responding date, so we did start getting things together to respond within 21 days. And then we were served more papers on this all being changed from Judge Stutzman down to you. And there was no response timing on that form. That's why we brought a response on the date of the hearing with our special occurrence forms.
Mr. Thorne, what's your response?
The court rules provide that once the defendants are in default, which they are, defaults have been entered against both Mr. and Mrs. Yoder for failure to respond with an answer to the complaint recognized by the Michigan court rules, that they no longer can participate in the defense of the action until that default is set aside, and that default has not been set aside. It's so I would object to any consideration of this motion filed here today. Is one, it's not a motion to set aside the default, and it's not been filed timely, and was not served upon me and the township in time to respond to it. We can't be expected to respond to something we're given during the hearing. This case has been pending quite a long time also. The whole jurisdiction issue and this oaths of office, they've cited some of these arguments before. The statute they're relying upon, which is MCL 85.10-16, is Fourth Class City Act.
Yeah, the case that they were quoting from is a city case, not a township case.
And I believe the court's aware that there are different statutes and acts in Michigan that govern cities and townships. And I will represent as an officer of the court that the Fourth Class City Act does not have anything to do with Colon Township. The Michigan Constitution, Article 11, Section 1, really requires any official that is a legislative, executive, or judicial officer to be an oath of office. A building a code official in the state of Michigan is not an officer either of the legislature, executive branch, or the judicial branch. And there is no state statute that I am aware of that requires a building code official to be to take an oath of office. And I know that Michigan Township Association backs that up.
Mr. Bonnefield, you can step down. I'll accept this for filing. We'll set it for a ruling. Again, I got it like 3 minutes ago. I haven't read it. I'll make a ruling on it on October 15th at 1:30. You may proceed with your motion for entry of a default.
Your Honor, based on our motion and the admissions in the verified complaint by having no answer filed, and the additional supplemental testimony given here by Lance Bonnefield today, I move for admission of the default judgment and permanent injunction that was submitted with the township's motion and brief in support of that motion.
I was looking for the order. As I indicated, these are circuit court pleadings and their on-base system is different than mine. Do you have a copy of that order with you?
I do, Your Honor. I have an extra copy of the default judgment.
I got a copy of the August 29th order.
And the Yoders were provided with that proposed judgment when they were served with the motion. It has not changed from that date.
I order. Skip to the order part. It is hereby ordered the plaintiff's verified motion for entry of default dated September 12th, 2025 is granted. The above finding of facts are hereby incorporated and made a part of this judgment. The defendants and their officers, agents, servants, employees, attorneys, assigns, or successors in interest, or anyone involved in participation with the defendants are permanently adjoined from performing any further work on the interior or exterior of this building being constructed on the subject property unless a valid building permit is issued for the building by the building code officials and the stop work or orders have been rescinded by plaintiff's building code officials. This is common. This happens all the time. The case right now when someone built a garage, and I don't know how well built it is, but they didn't get a permit. Or they build a house and don't get a permit. You'd be amazed how often that happens. At any rate, I order that. You're enjoined from occupying the building or allowing anyone else to occupy the building unless written authorization is obtained from the plaintiff's building code officials. If an occupancy permit is granted by the plaintiff using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and or pregnant women as a place to give birth in return for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. Plaintiffs, I'm going to put in here rental room or fees or donation. Plaintiff shall cause a certified copy of this judgment to be recorded in the Officer of Register of Deeds for St. Joseph County within 30 days of the date of the entry of this judgment. No money damages are awarded to Colon Township. Defendants are ordered to pay $304.38 in taxable costs in relation to this motion. They shall be paid within 30 days from the entry of this judgment. The permanent injunctive relief granted in this judgment supersedes the previous injunctive relief granted in the preliminary injunction order dated August 29th. The court retains jurisdiction of the case to enforce the terms of this judgment. From what I saw, that looks like a nice building, and it does look like a medical facility. I'm sure it could be used for something, but it can't be used for a birthing center. I'm going to accept this filing and this filing. I'll ask that the clerk date stamp these and provide a copy of this permanent injunction to the defendants. You have a right to appeal this, but there's a process that is to be followed. this one's a thornier issue. My recommendation is you simply continue your ministry at a different location. A lot of money was spent building this building without a proper permit and without inspections. And we had a case several years ago where a church, they did a large bunch of construction without inspections or permits. They got the girders up to support the church and they didn't match. It was a big mess and eventually it was rectified, but nowhere in the county can you do this, build a building without permits and inspections. So that's my order. I would ask you to go up to the, unless you want me to just mail it to you, I'd prefer to give you a copy today. Could you guys process this and bring a copy back down for the defendants? All right, you give those to us.
Your Honor,
Yes, Ms. Yoder?
I would like to reappeal both cases.
All right, you can do that, but you can't do it by saying I appeal. Any more than you can say I divorced you 3 times and be divorced. You have a process you have to follow. All right, Mr. Yoder?
Just for the record, I guess, so you know, we had a building permit, we had a foundation permit, we had a zoning permit, a well permit, a septic permit, mechanical permit, and a plumbing permit.
Well, that was my understanding that it started out, it was.
Now, why, if they give me the permits, they had the prints that they could see exactly what that building is. They knew exactly what the square footage is of that building because it's right on the permit. I've still got copies of the permit. Once the building is all built, they say you can't do that. The thing of it is, mister, when we got to the point, my wife says, we got to do something different. She's going to need a new building. I says, all right, you go up, you find out what we need. Because the only place I can put a new building is in 2 acres of woods. So I'm going to have to clear 2 acres of my woods so my wife can put a house in there. I says, I'm not clearing woods before we've got permits. Ain't happening. So they give us all these permits. She talked with Joe from Safe Built and told him what she wants to do. And he told her how to fill out the permits. Okay, so we had the permits. The building is all enclosed. Yes, it's not going to weather from the outside. But all of a sudden they said, oh, you can't do that because you need this and this and this and this. Explain that.
I don't know that I have an explanation. I agree. This was started. You didn't just show up in the dark of night.
It's totally uncalled for.
All right. The problem is they filed the action, the default entered, and now you raise your defense.
We filed personal or special appearance papers on every court case that was filed.
So you have this concept of oath of office and special appearance papers. The court didn't accept those as a pleading. As again, you need legal help, real legal help, somebody with a license and some understanding. And I would encourage you to continue to get it. You've got a not what looks like the bones of a very nice building there, but you can't use it for the intended purpose. And you're right. They let you start this, and then somewhere along the line, the wheels fell off.
Well, how can they do that?
I don't know, but they just did.
Your
So,
Honor.
all right, we're gonna be in recess. This matter is completed. You wait here, they'll bring you a copy of the order. You have a right to appeal it. We're gonna have a further hearing on October 15th, where we'll determine what the penalty is. And I'll have an opportunity to review your motion and rule on it. If you want to file anything else, you can file it and schedule for hearing on that date. All right, we'll be in recess. Thank you all for being here. This is a public proceeding and it's a healthy thing that people can actually.
Well, guys, we have finally come to the end of this contempt hearing dealing with Mr. and Mrs. Yoder. And I mean, we heard all types of different sovereign citizen lingo. We hear basically what's going on the property. but Judge Middleton found that they definitely was still in contempt of court. They didn't follow the rules. They didn't do what they were advised to do and told to do. And for that, he told them, listen, I suggest that you really seek legal counsel instead of trying to do these things on your own, especially with what it is that you got going on there and what you're trying to do. But basically, Judge Middleton, found them guilty of the contempt hearing. It's no need to go over all of it. We see all of the sovereign citizen lingo. We see that they try to use, the ministry as a means to be able to pretty much go against the law and whatever rules they have in place for the zoning and property and so on and so forth. But we made it. It was definitely 3 long videos. It all actually happened in one day, but obviously I didn't want to put a 2.5-hour video together, so I just broke it up in parts for you guys. But nonetheless, guys, that's it for now here at Sovereign Citizens Hall of Fame. I always appreciate you guys sitting in on these proceedings with me and just checking some of these different situations out. But listen, don't forget to like, share, comment, and subscribe. It is always much appreciated. And listen, for now, guys, Sovereign Citizens Court is adjourned. I'll see you guys very soon, and God bless.
Mr. Eagle-Sizer, how are you, sir?
Your Honor, how are you?
Very well. If you want to know about bed bugs, you should have been here a while ago.
I heard we had an outbreak.
All right, we've come to a somewhat unsatisfactory, or maybe satisfactory conclusion of our last case. We're still gonna have testimony to be heard. We're gonna move on to our next matter, which is another case with a long history. This is hearings in 2 separate cases. In the matter of Colon Township versus Alfred E. Yoder and Joanne Yoder. You're Alfred Yoder?
Yes, sir.
And you're Joanne Yoder.
Yes, sir.
And the township is represented by Mr. Lance Thornton, who is also present. Mr. Yoder and Mrs. Yoder have represented themselves throughout these proceedings. They have a right to represent themselves. I recommended they get counsel. They do have some legal advisors, but they are here on their own behalf. I had hoped to get to the end of the finish line here in this case, but we aren't there yet. We took a lot of testimony through the spring and summer. On October 15th, we had a final hearing, and the court issued an order for indemnification / restitution. And another order following civil contempt. Then there was another order issued on November 5th, and another order on November 5th regarding each case. Denying the motion to set aside the default and the original order for the cost portion of this. Mr. and Mrs. Yoder have filed a number of motions in each case. Kind of trouble sorting them all out. But I have before me a proposed order on motion for sanctions, order granting defendant's motion for sanctions and finding fraud upon the court. Proposed order granting defendant's motion for reconsideration, vacating void portions of prior orders. And then supporting that is entry to objection to entry of order and notice of inaccuracy under MCR 2.602B3. And then they filed a brief in support of application of law, recognition of compliance and void judgment doctrine. And a brief. And then they filed something called a declaration of AI forensic analysis and findings. I think AI assisted in preparation of these. Defendant's motion for reconsideration, correction of factual constitutional errors, and motion for sanctions and fraud upon the court. So I think there's actually 3 actual motions. Motion regarding cost, a motion for reconsideration and correction of factual orders, and motions for sanctions and finding of fraud upon the court. Mr. Thornton got the same set of pleadings I did. The ones I quoted from were from the 25040 case. And I believe there's a parallel set in the 25533 CZ set. So they filed a motion for reconsideration of the other matters, and the court can't simply ignore it. So we set them for hearing. Who's going to speak for you? You, Mr. Yoder? All right. I think we've resolved our question about all rise. I guess the simplest solution is just people that don't object just come in after we start and sit down, and then we avoid the whole rigmarole. All right, Mr. Yoder, what do you want me to know?
What don't you understand?
Well, I don't understand most of it, to tell you the truth. What are you asking me to do?
Well, I thought if I can understand it as a dumb Amishman, I got to the point where it actually makes sense.
I wouldn't use the term dumb Amishman. They're some of the cleverest people I've encountered, but so call me a dumb judge.
Well, as always, guys, anytime you're representing yourself pro se, especially if you don't know the rules of the court or how laws work, if you're representing yourself, whatever motions you filed, of course, they're going to make sense to you, but they have to make sense to the court and to the judge. It doesn't have to do with anybody being dumb, whether it's, Mr. Yoder or the judge, but it has to make sense. And we see here, Judge Middleton says, listen, help me to understand, why are you filing these motions? But to Mr. Yoder, it was like, it's not self-explanatory enough to you. And it's like, no, because it's not really making any sense.
So you filed these 3 motions, and I don't exactly know what it is you want me to do.
All right, let's run with the objection to entry of order and notice of inaccuracy under MCR 2.602.
All right.
According to the transcript from the last hearing, we were ordered to pay fines at a cost.
Yes.
All right. And this letter that I got,
Is it this one you're looking for? Because it's got the blank space. It has been taken.
The defendant shall pay restitution, Colon Township. Restitution amount leaving a balance of $2,449. Then the court said within 30 days, some reason or other, this paper that is left blank. This isn't the paper that I wanted because it's on that paper that we're held for civil contempt. We owe the township for incurred pecuniary losses and that restitution is owed. That's not even what the court said.
Well, I went back and watched the video. I've left these up. Usually I take things down on or after 30 days so I could review things. And I looked at what I said on the 15th. And it may be just a matter of semantics, but this payment is going to Colon Township.
I realize that.
Okay.
I have the transcript from that court date. Not with me, but we have the transcript.
Oh, very good.
And that's not the wording from the court.
Well, it's the wording that's in the order, and the court stands by its order. So, Mr. Thorne, do you wish to respond to that?
Sure. Defendants object, and part of the problem is their objections address two different orders, one in each different case, but they've got just one objection. So they object that to the finding that defendants committed civil contempt. The defendants did commit civil contempt, and the court made such a finding. Defendants further object to the language regarding the township incurring pecuniary losses and the restitution, that restitution is owed. Again, the court did make these findings. The court may have said costs, but it's not just taxable costs, it's restitution. And my motion for the restitution cited the MCL statute, and that's in the order. And the court agreed and ordered it under that statute. And that is for costs and restitution to the township. So we're not arguing over the amount. That was clear what the court ordered. Although I did the follow-up order because Your Honor had marked up an order that I had pre-prepared that
Looked pretty bad.
Yeah, so I clarified it with more time after the hearing. So again, the court did make those findings. So whether you call them costs or restitution, it was clear under what statute the court was ordering it, and it was clear that the court did order it. The defendants complained that the orders were not circulated before they were filed. I'm assuming they're saying before they were filed with the court. Well, the court rule doesn't require that they be circulated before they're filed. They were filed with the court under the 7-day rule and mailed the same day to the Yoders. That's the whole idea behind the 7-day rule. There is no requirement that the proposed orders be provided to the Yoders before they are given to the court. The court waits 7 days for the Yoders to present their objections. And then if no objections are received within that 7-day period, the court signs the orders. And in this case, the Yoders' objections come in after the 7-day period expired, but and the court did go ahead and enter the orders. So I'm not even exactly sure.
Well, the order complies with what I ordered.
Exactly.
And the court speaks by its written orders, and I went back and looked at what I said, and I tried to explain. I lowered some things that you had requested. We came up with the amount of $4,449.94. I allowed that the bonds that the defendants had been posted could be applied against that amount, and the amount remains the same, $2,449.94. So the defendant's objection to entry of that order is denied. Mr. Thornton, you can prepare an order to that effect.
Can we fill in the blank on the order as part of this order denying and how many days they had to pay the $2,449.94?
Let's see, Z 40. Yes, it should have said 30 days, but now an additional, so today is the 3rd. I'll make it 30 days from today. So the original order was within 30 days of October 15th. The amended order came in on November 5th. Was sent out. And so now I've reconfirmed it. So November 5th to December 3rd is 28 days. Paid within 58 days, amended. Defendants have 58 days from November 5th. Pay the balance. The $2,000 may be transferred.
That's been received, Your Honor. The court has transferred that to the township and I delivered them their check. So.
All right, you have essentially 30 days from today to pay that $2,449.94. So Mr. Thornton, would you do an objection denying or do an order denying that motion and granting the defendants 30 days from today to pay that amount? Yes,
It's not
Ms. Yoder?
necessarily the pricing, that's right.
Yeah.
That was correct, but it's the way it was worded here and then what the things that he reworded differently, that hits us because it's like, it's not exact, it's not how it was given in court.
Well, as I said, I
Reworded
listened to it, and the statute entails costs and restitution, and costs go to the court generally. In certain types of violations, they go to the city or village. Fines go to the libraries. That's a whole different can of worms in criminal cases. But this is a zoning violation matter with a civil contempt. So what I wanted to make sure was that the township got the money rather than the court. And that order makes that happen. And so I'm satisfied. And I did try to explain it, and maybe I didn't explain it very well. But that original order stands. You have 30 days from today to pay the amount stated, which is $2,000. $449.94. That's the first motion. Let's take the next one.
What date does that come up to?
Well, 30 days from today would be January the 2nd, first business day of next year. All right, that's this one. Next, we have trying to keep my motions. Motion for reconsideration and correction of factual and constitutional errors.
Your Honor, are you understanding it, what we gave you, or do you want us to read everything?
Well, no, I certainly don't want you to read it. I read it, but could you help point out exactly what it is you want me to do? I read it more than once. Some of this is AI generated and it's hard to track. It doesn't look like a normal legal pleading that the court sees. So let me ask, which I would ask any party, you filed a motion, what is it you're asking me to do?
Right, how can we have a case, a legal case, if there's a whole bunch of illegal stuff going on in it?
That's the essence of your view.
Exactly.
Okay. Now, as I've recited a couple of times, I came into this matter in midstream.
Yeah, I realize that.
It had been going on for some time, and you were given a notice of default. You did not appear. Default judgments entered. You did not move to set the defaults aside. I did not grant a motion to set the defaults aside, and I allowed both default judgments to stand. That happened all before I got here, and then I've been dealing with everything since then. And there's a difference between being ignorant and being dumb or stupid. You're not dumb or stupid, but people that aren't lawyers don't always understand the law. Sometimes the lawyers don't understand it, maybe judges too. So this stuff is complicated. And so you try to step back and look at it as a large framed picture saying something looks out of whack here. And then when you get into it and you take all the testimony and we take all the time that we did, I made the finding that I did. And I stand by it. And this is a recent phenomenon, particularly with AI assisted. You go through a long, arduous hearing, spend time at night, evening, going over everything, take all the testimony, make a ruling. Then they file a motion for reconsideration saying, well, I don't want to do this all over again. I already made my ruling. I don't want to go through the whole process in a reconsideration. Mr. Thornton, what have you made of this motion for, and I think they're parallel motions in both 4-0 and 533 case. The defendant's motion for reconsideration and correction of factual and constitutional errors.
Well, first off, the township opposes all the recently filed motions. And I'm a little confused because when I first got the 40 some pages of filings on October 31st of 2025, I contacted your Honor's office because I was wondering what we were going to do today on 12/3 of 2025, since there were additional motions filed in addition to the objections to the two orders. So, and I communicated by email with your Honor's secretary, and I was informed, and I have copies here if your Honor wants to see them, that the last response on November 5th was the hearing is just on the objections they recently filed to the orders.
What was intended, we were just gonna hear all the motions, so I'm not sure if something got lost in the translation.
So my
So
other,
you're claiming you don't have notice for hearing on these motions?
I don't, based on that, I didn't file a response to the motions. I'm wondering how many post-judgment motions the court's going to allow the defendants to file. I don't know what we're up to. I would have to sit through and go through the files. But there's been several in both cases, and all have been denied. And so, yeah, our position is no, I'm not, I didn't file a response. I'm not.
Well, every time they file something like this, with the aid of their assistants or AI, it costs the township thousands of dollars to respond to them.
Correct, and especially when we get them in the form of 40-some pages, addressing with the two cases mixed together, and the documents mixed together, and I have to take the time to sort through them, which I did take the time to read through all of them. Nothing has changed. The same arguments are being made that the court's denied in the past. So based on that and based on the email I had received from your Honor's office, I didn't file written responses. The township does object to the orders and opposes or objects to the motions and opposes the motions. The judgments have been granted. The defendants have not shown anything that would require the court to overturn its rulings. And as the court has stated in the past, if they didn't agree with your Honors in this court's rulings, they have the right to appeal.
Yes.
I'm not even sure where the appeal would stand at this point because of all the subsequent motions that have been filed post-judgment. So I guess if the appeal occurs, we'll have to sort that out.
Well, all right. Regarding this first motion for reconsideration and correction of factual and constitutional errors, it's got some exhibits attached to it. I don't comprehend it very well. Township objects to it, and I'm gonna deny it, and defendant can appeal that to the Court of Appeals with everything else.
Your Honor, and could I add for the record that all of these motions that get filed, the one thing the defendants do not do is set them for hearing.
Yes.
And get a hearing date and send out a notice of hearing, which is required of them to do. I realize they're not acting as their own attorneys. We all know somebody else is acting as their attorney, but that is their obligation under the court rules, is to set it for a hearing, prepare a notice of hearing, and serve it on me so I know what we're here for on any given day.
Fair response. In the courts, I don't know what, just a minute, I don't know what they would do in circuit court. In Judge Noacker's day, people would file something in the circuit court file and nobody would even look at it. It'd get put in there and it'd be a year and a half later and the parties called up and said, hey, what happened to my motion? I'm a district court judge sitting in this zoning matter, which I do lots of these, but it's in a circuit court context. with the circuit court county clerk being responsible. So I have to make sure that I'm complying with how they do things. But I said it, I didn't want to just leave it in limbo. So in each case, I've set these for hearing, and the motion for reconsideration and correction of factual errors is denied. You can appeal that also to the Court of Appeals. I don't understand it. Township objects to it, and if you can get the Court of Appeals to confirm it, then maybe they'll understand it better. They will not be lax upon the filing of the rules. They've got very strict rules on filing and briefing and deadlines. So that appears to be the third motion. That's in both the 4-0 case and the 5-3-3 CZ case. Now this one, I didn't understand. Motion for sanctions and finding of fraud upon the court. Again, I'm not exactly clear what that is. The two cases kind of intersperse. But this also has to do with the money, the $2,499.94, and you object to that order and you want finding of fraud. Again, I'm not sure I completely understand that. Mr. and Mrs. Yoder, what are you asking for in that case?
Well, I guess the way I understand the laws, if you read all this stuff, if the judge says one thing and the attorney writes letters stating other things, that's technically fraud. In my book, I'd say he's lying. Plain English. Like I said, we have the transcripts, and no, that does not match up with the transcripts.
All right.
So in plain English language, that's fraud.
Now this order, this motion is a little better because it has relief requested. You're asking me to find that plaintiff's counsel proposed order failed to conform with the court's oral ruling that was submitted in bad faith. 2, to declare the October 22nd, 25 written order void to the extent it includes findings or language not stated on the record. 3, strike any reference to civil contempt, restitution, or pecuniary losses from the case record. 4, impose sanctions, including defendant's reasonable cost for preparing this motion and correcting the record. 5, direct plaintiff's counsel to show cause why further disciplinary action should not be directed to the Michigan Attorney Grievance Commission for violation of conditions of the canons of ethics. 6, grant such order on relief as just and necessary to preserve the integrity of this court. That I can understand. I don't know if that was AI generated or otherwise, but I don't find that he committed a fraud. I don't find that the order was issued in bad faith. And in my earlier order, I've declined to strike those matters. And really, it's a matter of semantics rather than the amount, as I indicated, and I looked at the record from that day and tried to explain that amount. I calculated after hearing evidence. I deducted the amount of the bonds from that, and I wanted to make sure that the money went to the township rather than to the court or the state of Michigan. So your motions for sanctions and finding a fraud upon the court is also denied. I don't find there was a fraud on the court. I don't think Attorney Thornton acted in bad faith. he was trying to interpret my ruling as well, and the order accomplished that.
Your Honor,
Yes, sir.
can I call somebody to witness?
No. You can't. This isn't a testimonial hearing. I tried to get this case to the finish line, and to your credit, you have ceased birthing operations at Mama's house. We're working on getting the other building in a position where you can utilize it. You may wish to open your enterprise in another jurisdiction that would welcome it. I don't have any objection to that. But I wanted to bring this case to a close. I found my default orders remained in effect. I tried to calculate what I thought was a fair amount, which is much less than their actual costs. And I want to keep treading the same water. So I meant what I said on October 15th and in my previous rulings in this case. So each of your motions, motion for sanctions is denied, motion for rehearing is denied, correction of constitutional errors, and the objection to the order is also denied. Mr. Thorne, if you would prepare those, then you can appeal this to the Court of Appeals. My feelings won't be heard if the Court of Appeals disagrees with my ruling in this matter. I didn't seek this matter out, it landed on me. And I want to bring it to a close. So each of your motions was filed. You didn't notice them, the court noticed them. So township was a little bit confused as to what exactly we were doing. I may have added, I'm not out to look at that email response. Anyway, all three of your motions, the best one was the last one, but at least the best understandable one from my perspective. So we'll send you a copy of those orders. You have until January 2nd to pay the balance of that. We'll call it restitution. And if you wish to appeal it, I wish you all the best.
Your Honor, I would like to comment.
Yes?
The allegations of me committing fraud against the court and making misrepresentations to the court are offensive. As I stated before, we all know the Yoders are not drafting what they are signing and submitting to the court. The documents the Yoders are signing are being drafted by someone who is providing legal advice to the Yoders and who is covertly acting as their attorney. However, that person is ignorant of or doesn't understand the court rules or court procedure. And by signing those documents, everything stated in those documents becomes the Yoder statements and legal arguments. I practiced law for 36 years, and I have never knowingly misrepresented anything to this court or any other court, and the Yoders allegations, again, are extremely offensive. Your Honor made the findings and rulings that are set forth in the orders, and Your Honor signed the orders I submitted. I assume Your Honor would not have signed the orders if the orders failed to represent your findings and rulings. So I do appreciate the court's comments today.
All right, and they did, and you and your efforts have the respect of this court. You do a very fine job representing your clients. Yes, Ms. Yoder?
So we are getting help from different directions, yes. AI has been our crutch. Best thing that we could, best resolves that we could get. And AI is to the pushback. It is not illegal. That is legal. And AI does know.
Well, I didn't say that it was illegal. The legal world hasn't quite caught up to AR. Some of it can be very helpful. In fact,
It has been helpful.
it's gonna dramatically alter the practice of law. Right now, it hallucinates. It finds facts that aren't real. It makes things up. And parties have been filing stuff without properly vetting them. Some attorneys, and even some judges, have gotten profoundly embarrassed by not vetting or verifying the information filed in the briefs. I didn't make a finding that your information is false or a hallucination. I simply disagree with it. As this gets better, it is going to change the way we do everything in the world. I was at the judges conference in May in Detroit, and a speaker spoke to about 600 judges with an AI presentation on legal briefs, and we were stunned. So yes, it's certainly not illegal. It has its uses, it has its drawbacks, but I've made my ruling. I want you to pay that money by January 2nd to the county clerk. The matter will be concluded. If you wish to appeal it to the Court of Appeals, feel free. Yes,
Your Honor.
Yes, sir.
What did he say that happened to him when we filed that he had brought up on a court?
I don't remember, but you were here. I don't want to get into a
I
personal.
don't remember what the name he had for that. It wasn't humiliated or whatever he called
He was offended.
it. Offended.
Yes, that sounds like a good word. If I was him, I'd have been offended too.
How does he think that we're feeling with what we've got going on out there?
All right.
And we tried to be a plain person, live a plain life. We even asked him and his safe built guys for advice, and this is where we're sitting. Now, you think we're not humiliated?
I certainly would say frustrated. All right,
I'll
we'll
take
be
that
in
one.
recess. I don't need any further enlightenment. Thank you, Mr. Thornton.
Well, guys, we've come to the end of this motion hearing for Mr. and Mrs. Yoder. And as we can see, all three motions were shot down by Judge Middleton. They're still expected to pay the fine that they were originally expected to pay. Everything that they filed, the AI motion, all of the different motions, none of them really mattered because, lawfully, they didn't have a leg to stand on. And like Judge Middleton was explaining to them, listen, you didn't even really file these properly, but because we are a district court, we're being a little lenient on you. But when you start dealing with the circuit court, once you hit that level, they're not going to show as much mercy as we have shown. So the motions were denied. They still owe the money. Good thing they stopped the birthing operations that they were having at the facility. And hopefully they work all of this stuff out with the zoning, getting new property in a whole nother town or district or whatever they're going to do and go back to, living the lives that they've been living. Because I'm sure, them being Amish, them being the way that they are, just kind of to themselves, doing their own thing. I'm sure they don't want to be back and forth to court. But as always, guys, I appreciate you guys joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, share, comment, and subscribe. And until the next time, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. Thank you, and God bless.